Welcome. Thank you for coming tonight. We're pretty excited about this forum that we have. This is a momentous election, as you know, on November 6th, and we are trying to do our best to provide our college community, our university, and the public with information that will help you think about how to make your choice and which way you would go. In particular, we're going to focus tonight on the question of non-unanimous juries here in Louisiana. We have an all-star panel here with lots of different points of view. We'd like to welcome you from the University of Louisiana, also the College of Liberal Arts, the Criminal Justice Department, and the Political Science Department. I'm going to leave the introductions to our very able moderator. That would be John Burkhart, who is Field Director, Criminal Justice Field Director for the Southern Poverty Law Center. And remind you to silence your cell phones if you would, please. And hopefully at the end we'll have a chance for some questions and answer and so on. But in the meantime, I look forward to this experience, and I think we all will.
All right, thank you very much, Pearson, and thank you all of you for coming out. I think it's a general rule, but especially with the panel that we have assembled, a good moderator is someone who just can set them up and let them run with it. But I will just say that we literally have the person who wrote the book. We have another who passed the bill, and then we also have between the combination, it's the group that's going to change Louisiana history, a very shameful part of this history. And so the format of tonight's discussion is we're going to leave it to them. We're going to let these distinguished panelists tell us a bit about the history of how we arrived to this moment that we're at, and then we're going to follow up with another round where we talk about what's happening now and especially the next 4 weeks, and then we'll allow for some questions. So certainly write them down. Please don't be shy, and we look forward to hearing your thoughts. So. My name is John Burkhart. I work with the Southern Poverty Law Center, and I do criminal justice reform here in the state of Louisiana. So my own shameless plug is that we'd love for you to get involved. We, for the past few years, Louisiana has changed a lot of its practices and laws in a significant way that's caught the attention of the national media and the local media, and it's a thing, as we like to say. But we have a coalition called Louisianans for Prison Alternatives. And the reason we've been so successful is because people have decided that, reading despairing headlines is you feel powerless, but you can actually change, and we actually have shown that you can do that. So Louisianans for Prison Alternatives, and thank you for that. But there's another coalition at work here, and we'll get to some of those folks. So without much further ado, we'd like to start off with the man who literally wrote the book, Jim Crow's Last Stand, about the non-unanimous jury in Louisiana. I believe that came out in 2015, and I have a hard time believing that he's staring at the screen of a computer thinking, in a couple of years, this draft I have here is going to be this momentous, lead to a momentous movement, but here we are. So Dr. Thomas Aiello, I highly recommend getting the book, but I'd just like to ask you, would you mind providing us with a little bit of a overarching history of Louisiana's non-unanimous jury practice, and how did we get here?
Right, I absolutely will. So Louisiana initially always had unanimous juries, as had been the tradition in English common law, and had always been the standard that the United States has set. It decided to change that, however, in the Gilded Age, in the late 19th century, specifically as part of their broader response to the end of Reconstruction and the Redeemer politics that followed. After the end of slavery, after the triumph of Reconstruction, where over 1,500 black legislators from the South served with distinction at all levels of government, white people finally got control of the South back and decided to do whatever they could to restore a version of the antebellum South to their lives. And if they're going to do that, they needed to do a couple of things. First, they needed to take away black political power. They did that with various voter laws that could eliminate the black male right to vote. They also needed to control black bodies, and so even though they couldn't do that technically in the way they used to, they started passing segregation laws to kind of delimit what public spaces black people could enter and how and where they could enter them. But the other big part of kind of retrenching after the end of slavery is to get slavery back, is to get the thing that they felt had made them successful in the first place, and that was free labor. And to do that, they decided to use the one loophole in the 13th Amendment that says you are not allowed to keep people in bondage unless they're convicted of crimes. So Louisiana decided that it needed to start convicting people of crimes. And it did so. It created a variety of new laws that made convicting people of crimes easier. They passed laws against vagrancy, for example, and other kinds of very generic non-misdemeanors, criminal felony acts that they could get people into prison. And they started arresting them. Louisiana did this system that we know as convict lease in a unique way. Though most of the South did a version of this, Louisiana's version started with a state monopoly where they provided one guy, a guy named Samuel Lawrence James, with a 21-year monopoly on the control of all convict labor in Louisiana. There was some heady pushback on this, as you might imagine, because it looked like we were just privatizing all the prisons, and how would there be any oversight? Would the prisoners be allowed to escape and come kill God-fearing white people? What was going to happen there? And to make sure that he was able to avoid criticism, he decided to go and buy a plantation away from the mainstream where he could kind of headquarter his operation. The plantation that he bought was named Angola. And he housed convict lease there for decades, where he ran a prison farm that actually was a farm, but also leased out those convicts at an average rate of $5 per head to serve out their sentences for railroad industries, plantation owners, and other kinds of businesses that wanted free labor. And it was a devastating operation. In the best year that we know about in Louisiana's convict lease system, 18% of all convicts died. In the worst year, that number is over 25%. And in the worst years still, we don't know the numbers because they were lost because Louisiana wasn't interested in having them revealed. It was incredibly deadly. All of the potential safeguards of slavery went away. Slavery was an ugly thing, but if you were a slave owner, you had a vested long-term interest in making sure that your slaves had food and shelter and clothing because you wanted them to live a long time to get your money's worth. You wanted them to have children because it meant free slaves for you. All of those economic incentives went out the window in convict lease, and so these leased convicts were ill-fed, they were ill-clothed, they were never medicated. And the ugliness of that particular system is going to cause some people to question why we're doing this and whether it's really a good idea. Those people are the problem. We need to figure out a way to get around them. And one of the ways that Louisiana decided to do that was to make it easier to get people into prison so that we don't have to worry about some of those negative voices. And so starting in 1880, they passed a law that mandated that only 9 of 12 jurors were needed to convict someone of a non-capital crime. Now, that 1880 legislation doesn't appear to have been used in any kind of ubiquitous way across the state, but it cemented itself as a good way for James to get more labor, and it was remembered by allies of his. And so in 1898, when Louisiana got its new constitution, the same constitution that was proclaimed to be the constitution that was going to restore white supremacy to Louisiana, it codified that non-unanimous jury standard into the Constitution, the same one that gave us all of our voting restrictions and everything else. It has been there in one form or another ever since. The other side, the other thing that was going on while they were deciding to do this, was an interesting problem with black jury service. Because Louisiana had a relatively stable and relatively large urban free black population going all the way back to the 18th century, it did have, unlike neighboring states like Mississippi or Alabama, a legitimately pseudo-powerful black population in the Gilded Age that couldn't be dictated to in the way that rural black Mississippians could be, for example. And so black jury service, even though that was part of the attempt to eliminate black political power, still happened in Louisiana, much to the chagrin of these white people who were trying to seek this kind of redeemer control. If, they argued, we're going to have black jury service, and we know that the black population that qualifies for jury service in New Orleans is about a quarter of the population, and the best thing to do will be to make a quarter of the jury not really matter. That way, as long as we have 9 solid white folks on the jury, we can assure any sentence that we want. We don't have to worry about black jury service. This all came to a head in a kind of infamous murder case in New Orleans called the Greasy Jim case. A guy named James Murray, a black guy who had been convicted of murder, argued even at the trial that his grand jury had been all white and that his trial jury had been all white, and that he could not be said to have been tried in front of a jury of his peers in Louisiana if all of the grand jurors and all of the trial jurors were white. That case was taken up by a local citizens committee, the same citizens committee who would also take on the Separate Car Act, the first segregation law in Louisiana, the case that would ultimately become Plessy versus Ferguson. And while they were trying Plessy v. Ferguson, they were also trying the case of Greasy Jim. Both of those cases went through the appellate process, and both of them made it all the way to the Supreme Court. And in 1896, on the very same day, the Supreme Court ruled that segregation was okay in Plessy. And the same very day, they also argued that it was totally okay for Louisiana to keep black jurors off of the rolls. Now, that one didn't get as much coverage because the above-the-fold headline was always Plessy, the case that validated Jim Crow. But it happened on the same day. And this citizens committee got very worried and started to lobby Congress to try to get something done about this. So much so that they were able to get one senator in particular, William Chandler of New Hampshire, who was at the time an incredibly powerful senator, to threaten an investigation into Louisiana's jury system in 1898 if they didn't clean it up. 1898, of course, happens to be the very same year that they wrote that Constitution that made this quietly official and eliminated any need for them to kick black jurors off of the rolls. Because as long as you can assure yourself that you have 9 white jurors on there, it won't matter anymore. Now, that has continued on in the various iterations of the Constitution that have continued. It did change once in the 1973 Constitution. That was in response to a Supreme Court case in 1972 when the United States Supreme Court validated our system in a narrow 5-4 decision called Johnson v. Louisiana, decided in conjunction with an Oregon case called Apodaca v. Oregon. Oregon is the only other place in the country that does this as well. And as part of a judicial efficiency compromise that happened the following year when we decided to write a new constitution after that, we ended up aligning our jurors with the Oregon standard while we actually expanded it to cover all non-capital cases. So it was a compromise measure. And so today, we are left with a 10-2 majority system for our juries. juries. That is the kind of the basic kind of Cliff Notes history of that.
Excellent. So you should definitely check out the book if you're not already intrigued. Thank you very much. Speaking of history, we have next to him Mr. Ed Tarpley, who's the former, just always a criminal justice reformer. Actually, he's the former district attorney from Grant Parish. A really interesting thing about this is that during the hearing of what was Senate Bill 264, which ultimately became this constitutional amendment we'll vote on, the district attorneys were initially against this bill. And then there was a pretty famous foot and mouth scenario in House Administration of Criminal Justice. And this bill needed 2/3 to get all the way through, and we're here today because it did. But Mr. Ed Tarpley played such a large role in that. And Ed, I guess I just want to ask you to take, you're a former district attorney. Would you mind talking us through a bit about your personal history, which obviously includes part of Dr. Aiello's book, but just, tell us how you got to this point.
Well, I think that for myself, reading Dr. Aiello's book in August of 2015 was a real turning point for me, because even though I was familiar with the fact that Louisiana had a law which allowed a prosecutor to obtain a conviction with only 10 votes out of the 12, I was unaware of the origin of the law. We all knew that was the law because we practiced law, and that was the law in Louisiana state courts. As a district attorney, my office had obtained a conviction, at least one that I recall, in which the vote was 10-2. Years later, after I became a defense lawyer, after I'd served in public office, actually had a defendant convicted by the vote of 10-2. So I had the opportunity to see the law work both ways. But I was unaware of the Jim Crow origin of the law until I read Dr. Aiello's book. And, I have to say I'm grateful to him for writing the book. I'm grateful to LSU Press for publishing the book. And it's been a life-changing book because for the first time in my career, I became aware of the shameful and odious past that this law comes from. And once I read the book, I remember telling my wife, Deb, who's sitting here in the audience tonight, that I was going to do everything in my power to see that this law was repealed, that I was going to make it a life goal, that God had put it on my heart, that this was an evil, wicked, and immoral law, and that it needed to be repealed. That this law had gone far beyond its Jim Crow origin to affect every citizen in our state, and to have done so for 138 years was an amazing and unbelievable fact. And so at that point, I began to talk to my friends about it, and then in the summer of 2016, I authored a resolution for the Louisiana State Bar Association, which adopted the resolution, putting the Bar Association on record as opposing this law and asking the legislature to repeal the law. That took place in June of 2016. And then amazingly, and miraculously, 2 years later, we have the Louisiana legislature do the very thing that the Bar Association had asked the legislature to do, and that is to pass an amendment repealing the law, which of course the people of our state will get to vote on in just 4 weeks. I just have to say that when you look at the fact that this law bears no resemblance to the right to trial by jury that James Madison and John Adams and Thomas Jefferson knew and believed and understood the jury trial right to be, then it's even more amazing, because even if you take away the Jim Crow origin of the law and just look at the law and realize and understand that we have been deprived of the full protection of the right to trial by jury, that unanimity is the core of the protection. It's not the size of the jury that counts, it's the unanimity of the jury that counts. And that's why John Adams said it's the unanimity of the jury that preserves the rights of mankind. This is John Adams. And Sir William Blackstone, one of the great English legal giants, indicated and wrote and said that it's the trial by jury that is the great bulwark of liberty. And that's how strongly that he felt about it. And so what we have in America, in 48 states, is what was brought down from the English common law. The trial by jury goes all the way back to the Magna Carta. It's over 800 years old. And the unanimity of all the jurors is the most essential and significant part of the jury trial protection. Because how can you say a person has been convicted beyond a reasonable doubt if one or two members of the jury still have doubt? It's simply illogical. It doesn't make any sense. And it goes against everything our country stands for, with the presumption of innocence and proof beyond a reasonable doubt. Those are two of the cornerstones of the American justice system. And sadly, in Louisiana, we have been deprived of this for 138 years. Once that really sunk in, I said to myself, we have got to get rid of this. And we can get rid of it. Because fortunately in America, we have a thing called federalism, which means that states can decide what they want to do in their state. And even though lawyers had litigated and advocated for years and asked the Supreme Court to overturn this law in Louisiana, we the citizens can change it. And that's what I became convinced of. Let's stop worrying about the U.S. Supreme Court. Let's go to the people. And the way we do that is we go through our elected representatives. And that's our senators and our state representatives. And I believe firmly, and even more so now, that once our people, once the citizens of Louisiana understood what the issue was, that they would say, yes, let's restore unanimity to the jury in Louisiana. Let's restore unanimous juries. We had unanimous juries from 1803 to 1880, 77 years. Let's restore what we had. We can do it. And I'm convinced we can, but the fact that we're having this panel discussion here proves the point. We're having this discussion. You're here in this audience. You're the citizens. You get to vote. We can change the law. That's my story.
Mm-hmm. Stick to it.
Thank you very much. So, Mr. Tarpley speaks from the experience of a former, of defense attorney and prosecutor, and then right next to him is Mr. Norris Henderson, who's the executive director of Voice of the Experienced, and he's also leading the Unanimous Jury Coalition. As someone who works in criminal justice reform, I will say that Norris is essentially the source of the river for everything that's happened in Louisiana, because a lot of this movement started behind the prison gates. So Angola was mentioned. Norris was there. Norris, would you mind describing, just from the client, the formerly incarcerated, the currently incarcerated, what the unanimous jury, or the non-unanimous jury practice means in Louisiana?
It is huge, because I'm the product of a non-unanimous jury verdict. I spent 27 years, 10 months, and 18 days in prison for a crime I didn't commit. And when my lawyer polled the jury, and the jury was 10-2, I looked at my lawyer and I said, "You did a good job." But the next thing I realized, the sheriff deputy was putting handcuffs on me and taking me to the back. And I realized in that moment something is wrong. All the Perry Mason stories I had watched, all the Colombo stories that I had watched, that something was wrong, that this wasn't a unanimous verdict, and I was still going to prison. But while in prison, I worked in the prison law library for over 20 years, and seeing men over and over and over again come true. And we had, one of our strategies in the library was, one, look at the closing arguments, look at the polling, and see what the verdict was. One of the cases that was mentioned earlier, Johnson versus Louisiana, Frank Johnson, I grew up in the same neighborhood, 2 blocks from Frank Johnson, as a little kid. And realizing after being in prison, trying to figure out how did I still wind up in prison with part of the jury saying, no, we didn't completely believe the story that was told, finding out that our United States Supreme Court upheld this practice in Louisiana. And one of the striking things about it was Louisiana, as kind of like backwards as other places are, Mississippi and Alabama, that they were far ahead of us in reference to this. But nobody understood, just like Ed was saying, that connection to what this ugly history. And then hearing Professor talk about Samuel James and that plantation, that's 18,000 acres of farmland, and as he described it, as we speak today, there's a case that opened up in federal court challenging still the medical conditions and the treatment of people still in their prison today. And so when we look at how, from way back then to where we're at now, and you think about all the other implications of that prior to 1986, that district attorney files and police reports were not public records. I went to prison in 1974. Police reports weren't public records, nor were DA files. In 1986, when I got my district attorney file, I learned that the victim identified somebody who was already in prison. So you factor that along with this 10-2 verdict, and you kind of like get a sense that how it was so easy to put people in prison. And then reading a lot of closing arguments in people's cases where district attorneys would literally be advising the jury pool that I don't need but 10 of y'all. I don't need all of y'all, I just need 10 of y'all. And so whatever controversy that would erupt in that jury pool, it was like, once we get the 10, ball game over, we out of here. And so it made it that much easier. The challenging thing about this is that it has taken us so long to get here. But I'm like Ed, I'm confident that on November the 6th, the good citizens of the state of Louisiana is going to understand from whence they came and kind of like rectify this. This is one opportunity, and I tell folks all the time, this is our one shot. This is our one opportunity. We have to take it. We have to take this opportunity to right this ship in a sense that so many lives, and we were talking out in the hallway, and literally 40% of folks who have been exonerated all had 10-2 verdicts. Now just think about that. And just here in Louisiana, the Innocent Project was created in 2001 here in Louisiana. 2001, that's not that long ago. That's not even 20 years ago. And they have exonerated almost 40 people who shouldn't have never been in prison. Not counting the ones who were on death row. You know, a personal friend of mine who is dead now, and I literally say the state didn't execute him, but they killed him. He died from a heart attack years later. But he challenged his wrongful conviction, got released from prison, sued the state, and lost the judgment. And he lost the judgment because they said, well, the prosecutors, that wasn't a pattern of practice. And so all these things kind of like tie in where it gave them cover to do the things. And, it's kind of like unique with Ed because Ed, like he said again, he's seen both sides. The side of it when it was easier for him to get a conviction, primarily because he didn't need everybody to convince. But then he kind of like had that kind of like lump in his throat when his client lost a case by the very same method. And it kind of like he said again, it inspired him that something is wrong with this picture, that I'm on both sides of this coin, and I've kind of like, I ain't gonna say won and lost because technically his position is that he lost on both sides, and this is why we're trying to change that. But we can't do it without y'all. We cannot do it without y'all. And, my hat's off to Piers for setting this panel up, for having me and Ed here a month or so ago to talk about this issue. Because if we don't have this conversation blows completely by people. Because nobody pays attention. Everybody assumes, the same way I did at 19 years old, that if you go to trial, everybody has to vote to send you to prison. And the uniqueness about Louisiana is that you can go to prison for the rest of your life on a 10-2 verdict.
That's right.
And that's what's really shocking about this. And so I think as we move forward, I think this conversation is kind of like that first step in this 1,000-mile journey that we've been on. But I think we are kind of like turned in the corner in the sense of educating people. And the thing I tell people all the time, that once you hear the truth, it's your responsibility to pay it forward. It's your responsibility to share it. And so your charge tonight, that after hearing this, you don't have to take my word or Ed's word or professor's word, but you have to look into this yourself and ask yourself, this ain't about who's right, this is about what's right. And that's what this is supposed to be. This is about just righting a wrong that has lingered. And in the title of his book, Jim Crow's Last Stand, because we know every other vestige of Jim Crow has technically been demolished. You know, there's no segregation, there's, you know, in the schools and with Plessy versus Ferguson, with transportation, all those things have been removed. There are kind of like still some challenges in different places, but this is Jim Crow's last stand. This is our opportunity to end Jim Crow in Louisiana as it exists. And I think once we do it, I think the state of Oregon will follow suit, because nobody wants to be last in everything that other people are first in.
That's right.
That's absolutely right.
Right. Well, thank you very much. And you mentioned the Innocence Project, and right next to you we have Mr. Frank Neuner, who, pardon me, I'm going to omit several of your titles and distinctions, but he's a private attorney here in the Lafayette area, and he is a board member on the Innocence Project in New Orleans. And he has also served, and he's very active in the business community, but he's also served as a chair of the Louisiana Public Defender Board. So over the years, he's been very involved in reform efforts. He's seen the system from various, from some other sides. And Frank, just love to hear, you know, your history with this. We're at this moment. What you have seen in these various organizations and roles that you've had.
So my story starts in 2005 with Hurricane Katrina, and I was president of the state bar at the time. And the Katrina floodwaters, all the damage that they did, the one thing that positive they did is they washed away the terrible criminal justice system that we had in Orleans Parish and some of the other parishes that were affected, and caused the state bar, which I was involved with at that time, to start a criminal, not start, but to try and collaborate with people that had already been working on criminal justice reform. And the state bar was able to bring people together, and we had DAs and we had criminal defense lawyers and public defenders, and we created an act called Act 307, which was enacted in 2007 to create the Louisiana Public Defender Board. And prior to 2005, I had literally no experience with the criminal justice system. I had a lot more friends who were DAs or assistant DAs, and probably no friends who were public defenders, and very few friends who were criminal defense lawyers. But anyway, since Katrina and my experience with the state bar and then the Public Defender Board, I've really seen the problems we have with our criminal justice system in Louisiana. We still have tremendous strides to make. It's much better than it was, but it's nowhere near where it needs to be. And the last 4 years, I've been involved with the Innocence Project in New Orleans. And the Innocence Project was one of the major supporters with Senator Morell's bill in the legislature and lobbied. And I've met a number of our exonerees, and it just breaks your heart that one person to go to prison who shouldn't be there. I'd rather see 100 criminals go free. And it's just to me, it's the right thing to do, especially when you get educated, as I have been by Professor Aiello and Ed Tarpley on the history of the law. Then how can anybody with a conscience and a heart support non-unanimous juries when you look at how it started? So that's where I come from. I represent businesses and litigation. I don't do criminal defense work. I was chair of one Acadiana last year, but even one Acadiana came out in support of this amendment to constitutional, constitutional amendment 2 on your ballot. And it's interesting that, I can't say that all my friends are in favor of it, but I'm proud to say that Keith Stutes, the DA here, will at least talk privately about it. He's wants to keep a low profile and not go public, but the good news is he says if I can't get a unanimous verdict, I shouldn't get a verdict. So, and I think that's the people who really are interested in justice are of that same belief that that's the right way to do it and the way the founding fathers set it up. So we'll talk a little bit more about who else is supporting this later, but to me, it's just the right thing to do. It's time to do it, and you've heard from the voice of experience next to me who suffered from a non-unanimous jury, and how can any of us in this room live with that on our conscience if we let this continue? So, thank you.
And then our final panelist is Kelly Garrett, who's the field director for the Unanimous Jury Coalition here in the Lafayette region. And I met Kelly, I think, first time about a couple years ago, and I think she was in some sort of sales for a media station and was not just filling out applications to get involved in criminal justice reform, but was really clamoring to just jump and leap into the work, and has been a part of some really monumental changes. So Kelly, I guess, what have you seen, and what has inspired you and to go full bore into this and to narrow down to this issue?
Well, as you mentioned, and as Mr. Neuner stated, I don't come from a background of any experience with criminal justice. I was in corporate America for many, many years, and I had a coworker whose son had been wrongfully convicted and at the time had been incarcerated for 15 years for something that he had never done. And I worked with her for a good number of years, probably 10 years, and me not having any kind of experience whatsoever in the criminal justice system, I always thought, well, you're his mom. You're supposed to be his #1 cheerleader. Nobody would be in prison if they were innocent. But then I met him, and I got to know him, and I got to know his character and his personality, and realized that this person cannot be who they say he is. And me being the person that I am, I did a lot of research. I looked through all his files, his court papers, and I was appalled at what I was reading with how the conviction came about. It was very, very unfair and unjust. And at that point, I realized that as a tax-paying voting citizen, that I can't just sit here and do anything about this. I have to be involved. This is a country where you vote on things, where tax-paying voting citizens have a voice. And I executed my voice, and I jumped right on in and got involved with as many and any organization that had to do with criminal justice reform, because at that point I realized, and I've seen, and I talked to many people. Mr. Norris Henderson was one of my first persons that I actually met and got to know, and just hearing their stories. It just astonished me that we were living in a country or in a state and a community where this is actually happening. And I couldn't be quiet. So I got involved. I had no experience, and I learned and still am astonished by a lot of the things. We live in a state that has had, up until a few months ago, the highest incarceration rate in the world. The world. We live in a state where we also have the highest exonerations. And up today, the ACLU actually filed suit where we have the highest death toll in our prison systems. And my conscience and my heart just can't be quiet about that. And so I got involved with Louisianans for Prison Alternatives very, very early on. And 2016-17 helped to push the 10 bill package, the reinvestment package that came through. And every bill that has come aside since then, I've supported and just wanted to educate my community members, my friends, my network of what's going on in our communities in this state, and enlightening them on some issues so that they can make good choices when they go to the polls. So that's my story, and like many of you, I don't have that experience, but I just couldn't sit still and be quiet about it.
All right, so let's now discuss the here and now and a few announcements about that. 1 week from today, October 16th, is the final day to register to vote.
That's online.
Online. Today was the last day in
Today was
person.
the last day in person.
October 23rd through the 30th, with the exception of the Sunday of that week, but the 23rd through the 30th is early voting. And then November 6th, Tuesday, November 6th, is the election. And that is Amendment 2, so a yes vote on Amendment 2 means that you want unanimous juries. A no vote means that you want to preserve essentially this history that we've been discussing. I'll tell one thing that I'm going to do in the here and now is I'm going to report on Friday to Criminal District Court in Orleans for jury duty, and hope I don't get chosen to do the work, but it is my constitutional right and privilege to be there Friday morning, so I'll do that. But I guess, so Dr. Aiello, I just wanted to throw it to you. I'll allow you to do free reign if there's other points that you think need to be covered, but I was really struck in reading your book about some of the near misses that we had, Supreme Court justice ailments or changes,
Right.
Because we have this historic opportunity in 1 month. Other chances to get rid of this practice or to change it. Of course, I'll give you free reign if there's something else that we need to know about this practice, but that's what came to mind. reading your book.
Well, you're right that the decision that ended up validating our law in the Supreme Court was an interesting one in that it was argued twice before the Supreme Court. In between the first argument and the second argument, we replaced 2 justices of the court. In justice deliberations after the first hearing, it was clearly a 5-4 decision in favor of ruling non-unanimous juries unconstitutional as not applying the 6th Amendment and the 14th Amendment to the states. But in the interim between the first argument and the second argument, 2 of those yes votes were replaced by Richard Nixon with 2 very different kinds of justices who ruled the other way. And so what was a 5-4 majority to repeal non-unanimous juries became, after the second argument, by almost just kind of bad luck more than anything else, 5-4 the other way. So we were literally that close to getting rid of these in the 1970s and kind of lost that ability because of the replacement of Supreme Court justices. We all have been talking a lot about Supreme Court justices lately, and certainly they matter in the way that these decisions are handled. What
And
else
I guess
do you wanna talk about?
another follow-up is that you wrote this book a few years back,
Yeah,
and here we are. You're
right.
going around Louisiana. What is that like? What are you doing? And did you ever think that so soon this would happen?
Right. No, I usually just deal with dead people. I mean, historians do not really live in the moment here. And I have written a lot of books in my life, and most people don't care about them this much. And certainly they don't. Well, I will tell you that the reason I wrote this book is that I grew up in Louisiana. Even though I don't live here now, I grew up in Louisiana, and I never knew about this. I had no reason to be in front of a judge when I was growing up here, and so if you don't have that, I mean, you wouldn't know. How many of you before today knew this was a thing? How many of you didn't know? Right? So when I found out about this, I actually didn't live in Louisiana. It was an academic thing more than anything else. It wasn't. It was just through this other kind of ancillary research, and it shocked me that was a thing because I wasn't a Perry Mason fan as much, but I was a Law and Order fan, and same thing there. And you always assume this. How in the world could this be? And historians, whenever we hear things like this, we want to go find out why. And so I came back and started digging in the law library and the archives to try to figure out why this was. And I did it because it was very frustrating. And I'm glad this is happening, and I very much appreciate everybody's interest, and I really hope this works. But no, most of the time when you write history, it doesn't end up helping to change a law. I really don't know how to even process it, really. I just kind of hope it works, and I want the best for my home state, even though I will not be able to vote on November the 6th. Well, I will, but just for other stuff in Georgia that you don't care about. But I will be rooting for all of you from afar and watching with bated breath online and on television.
The accidental celebrity.
It's not a good place.
My mind is blown just thinking about it. And you played, Mr. Tarpley, you played such a huge role in passing Senate Bill 264. We're in the legislature a lot. You were working tirelessly about that. Would you mind just sharing a bit about how that came to pass? Nobody thought going into the legislative session that this bill would pass or that we'd be here, and you worked so tirelessly for it. So just tell us a bit about that.
Well, the Bible says that faith is the evidence of things not seen, the substance of things hoped for. And it was faith that led me on. I had faith that God could do this. I really did. Because once it settled into my soul and spirit that this was truly an evil and wicked law, and that it had affected generations of people in Louisiana, black and white, rich and poor, and that it still affected us today, that for me there was not any question about whether this law could be changed. It was only when it would be changed. And I believed it could be changed now. And I felt firmly that if we just could get the truth out, that things would happen. That light dispels darkness. And this was a dark moment. This was a dark law that had come from an evil and wicked purpose. And yet it had forgotten. It had been forgotten. It had been lost in the mist of history. It had vanished. People didn't know about this. I'd practiced law for 35 years and had never heard a thing about this. Not in law school, not in a seminar, not in the bar association. Never, not a word. The shameful part of it is I never gave it any thought. I guess I was like the other 20,000 lawyers in Louisiana that never gave it a thought. Because if somebody had ever thought about it, we could have changed this years ago. But we didn't. Oh, that's on us, all of the lawyers in Louisiana, that it took us so long to get here. But I'll have to say this, that, look, I don't know what Tom Aiello thinks, but God had him write this book. Because if he hadn't written this book, we wouldn't know about this. And we still wouldn't be having this conversation. So I'll tell you what, I bought this book on August the 31st, 2015. And I read it within just a day or two. And after I read this book, I said to myself, we've got to get rid of this. And we can do it. And we have done it. And we will do it. There's no doubt in my mind. Oh, I'm just telling you that one of the most amazing things about this is how we have people from all points of the political spectrum supporting this. Republicans and Democrats, liberals and conservatives. We've got the ACLU and the Louisiana Family Forum on the same side. On the same side.
Right.
Okay, pushing for this law. Let me tell you something. Look, everybody can support liberty, and this is about liberty. That's what this is about. It's about liberty. The framers of the Constitution thought liberty was so precious that they believed that you could not lose your liberty unless everybody on the jury voted, unless everybody agreed to it. That was a safeguard put in there. Let me tell you, probably one of the most conservative justices that ever served is the late Antonin Scalia. And he was a solid supporter of unanimous juries. In the Blakely case, he wrote, and I'm going to quote this, just a couple of things real quick. He said that the right of jury trial is no mere procedural formality, but a fundamental reservation of power in our constitutional structure. Just as suffrage ensures the people's ultimate control in the legislative and executive branches, jury trial is meant to ensure their control in the judiciary. In other words, the unanimity of the jury embodies the essence of liberty, because you cannot take away someone's liberty unless the jury decides to do that, not the government. And the jury is not the government. The jury is the people. The people compose the jury. You picked at random to serve. That's why the jury is so important. And that's why unanimity means that every voice on the jury counts, even the dissenting juror. Scalia goes on to say that the very reason the framers put a jury trial guarantee in the Constitution is that they were unwilling to trust the government to mark out the role of the jury. Think about that. This is Antonin Scalia talking. And by the way, he was one of the greatest justices criminal defense lawyers ever had. I'm telling you, he was great. And he ended up this opinion by saying this, and I've quoted this all over the state. This is one of the great quotes of Antonin Scalia. He said, "The framers would not have thought it too much to demand that before depriving a man of his liberty, the state should suffer the modest inconvenience of submitting its accusation to the unanimous suffrage of 12 of his equals and neighbors, rather than a lone employee of the state." He's quoting Blackstone when he wrote that in this opinion. This is Blakely versus United States. It's a great opinion. And I've quoted it because we have conservatives and liberals leading the charge. This is a bipartisan effort. The bill passed the state Senate 27 to 10, and it passed the House of Representatives 84 to 15. It was overwhelming. We had the Republican president of the Senate, the Republican Speaker of the House, the Republican chairman of the House Criminal Justice Committee, all in support of this. It was an incredible moment. But let me just tell you right now, it didn't happen by accident. God moved on the hearts and minds of people in the legislature who were opposed to this bill, and he changed their mind. He changed their mind because this is about liberty, it's about justice, and it's about fairness. And let me tell you one last thing. The Bible says if you know the truth will set you free. And that's what this is all about. This is about the truth. And when Dr. Aiello wrote that book, he wrote the truth. And when I read that book, I read the truth. And when we talked about this, we're telling the truth. Just like Norris is telling the truth, and Frank Neuner, and Kelly Garrett. This is about liberty, and all of us can agree on liberty. So for me, this is a moment like we've never had in our state. We might not ever see another moment like this. I hope we do. I hope this is the beginning of great things. But I can tell you right now, this is our moment. Let's don't mess it up. Let's get out there and vote, and let's tell our family to vote and our friends to vote, and everybody we can. We can do this. We can do it.
All right, and Mr. Norris Henderson is actually quite a bit of a leading national figure, and I just wanted to get, Norris, if you could speak a bit about this issue, but also in the context of everything that's happening nationally. You know, criminal justice reform is a national conversation. Some big things happening in Florida on November 6th. So just, you know, starting from Angola, but here we are, this national conversation and movement. Just talk about your perspective in this long road and where we are and where we're going.
Well, I think the first thing is kind of like just following Frank too, is about us having to be proximate, having to be close to this. I'm probably closer than probably everybody else, but it's being proximate to these issues that I believe that those who are closer to the problem are that much closer to the solution. And so understanding that and looking at the reforms that are happening, not just in this state. I mean, it's monumental what's happening in Louisiana, what we've been able to accomplish in the last 2 legislative sessions. I mean, it's unheard of stuff.
That's right.
And so I'm like, Ed, this is bigger than us. This is a God thing. God is
Absolutely.
kind of like moving this thing.
No question.
And we just happen to
No
be the
question.
vehicles that it's moving through.
That's right.
And I own that in the sense of being a vehicle that these things are moving through. And I look at even my circumstances that God put people where they need to be.
That's right.
Had I not been to prison, I'd been just like Kelly, you know. Well, you know, my grandma used to always say, you're not in back of the police car for nothing. You had to do something. And I would venture to say if my grandmother was alive today, she would be kind of like just shaking her head about how jacked up things actually are. But I say that primarily because through these kind of like trials and tribulations, we kind of like open our eyes to things. We start seeing things in different ways. And we start seeing what is actually wrong. But then at that point, we have to make a decision. What do we do? I mean, sometimes being on the cutting edge of change, you don't benefit from change you bring about. And seeing that over and over and again. But there's a movement, there's a groundswell in this country that is really about holding this country to the premise of that all men are created equal in this country and that we should want for our brothers what we want for ourselves. I mean, this work around the criminal justice stuff, like we look, John mentioned Florida. In Florida, there's a ballot initiative also in Florida, Amendment 4, that's looking to restore the right to vote to over 1.5 million formerly incarcerated people who have been disenfranchised for life. You know, that shouldn't be in America. This was the country that was founded on no taxation without representation, but yet we have people in this country who can't vote. Just last legislative session, the right to vote was restored to folks here in Louisiana that's on probation and parole. And even there is no nexus, and this is the real thing about a lot of the laws when we talk about this unanimous jury verdict. There's no nexus between a person going to prison and a person losing their right to vote. No judge in America has sentenced anybody to prison to lose their right to vote. But it was one of the things that people have extracted away from folks. And all that plays a role, because when we go back to the jury pool, John says he's called for jury on Friday. If John was far from incarcerated, he wouldn't be on that list. If John had lost his right to vote, he wouldn't be on that list. That list comes from registered voters.
Right.
So you can see the connection to all of this stuff. It started off in one arena, and then they figured, well, you know what? Well, if I can't send him to jail, well, if I keep him away from this, he would never have an impact in that. And so when he said 25% of the African-American population, and so you're talking about, at that time, it was like you needed 3 people, and it was like, okay, any 3 of them said that doesn't matter because we still got the majority. But now if you kind of like decimate the pool of people who can actually qualify to show up, then it's altogether is a different ball game altogether. And so we have to be proximate to what these problems are. And the more we become educated about what these situations are, we have to make a moral decision. We have to make a moral decision about, again, it's not about who's right, but what is right. And I think when we get to that point, our values guide us at that point. You know, and one of the things he quoted, no, it was Frank was quoting Douglas when he was saying that I'd rather for a guilty man to go free than an innocent man to go to jail.
That's right.
Because it's about, again, it's about the process. It's about what due process is supposed to be and how we hold these systems accountable. And I think we have kind of like just fallen off the wagon by just assuming that these things are going to take place in and of themselves, when in fact they won't. We say, we ain't going to vote because then people are going to do what they want to do. I guarantee you they're going to do exactly what they want to do if we don't vote. We have to participate in the process.
That's right.
And I tell people all the time is that participation is the accountability. And when we talk about the value of people on the Supreme Court, we just saw a knockdown, drag-out skirmish about putting somebody on the Supreme Court. So you understand the value added. Now, we're talking about something from 40 years ago that's impacting people's lives in one decision in 1970 because two people during the Nixon administration left the court. He put two people in place, and had that not happened, we wouldn't be having this conversation today. But everything happens for a reason. And I think it's time now for us to seize this opportunity, to seize this one opportunity we have to change history of how Louisiana do business in the criminal justice arena in this state. And to the extent that, you know, all the lawyers in the room know, it's from the facts come the law, no other way around. You can manufacture all the law you want. You can put up 1,600 law books and manufacture the law. But if the facts don't hold true, that case gonna fall apart. So it's from the facts come the law. And if a prosecutor has facts, he should be able to come back with a verdict. If he don't have facts, you know, again, it's from the facts come the law. You can't have your cake and eat it too. And so I think it's essential that we kind of like catch this wave of reform that's moving not only through this country, but particularly that's moving through our state.
That's right.
Because next year this time, we're going to have a whole brand new legislative body. We don't know what the mindset of those folks coming in is going to be like. We don't know if the few things we got done last year is going to be able to stand the test of time. But I guarantee you one thing, if we pass this amendment on November 6th, it's going to be a game changer in the way Louisiana conducts business.
No question.
Thank you. Yeah, I will say those elections are 1 year from now, so if you're running for office, you're going to look at how you're going to look at the vote from this year if you're going to be going there to uphold criminal justice reform. I completely agree with Mr. Ed Tarpley in talking about the power of a concept like liberty. I think that really worked here. But Frank, this is an issue that's been bipartisan, and not sometimes one word can mean something to one group versus the other. Would you mind talking a bit about the Republican groups, the business groups that are on board with this, how that came about, and what they're doing?
Well, one of the biggest supporters of this is the Koch brothers and Americans for Prosperity.
That's right.
They're putting a lot of money into ad campaigns that started this week, and they're a very conservative group. They're against taxes, and they weigh in on lots of issues, but this is an issue that they weighed in on with ACLU and with criminal justice reform, which they have been involved in. And I think the reason for that is, if you think about it, our incarcerating all these people in Louisiana hasn't made Louisiana any safer.
That's right.
I mean, it's no safer today than when I started practicing law 42 years ago.
That's right.
And it's not helping, so we got to do something different, I think Aristotle said the definition of insanity is doing the same thing over and over again, expecting a different result. And we've been spending so much money we spend more on incarceration than we do on higher education per person, which is crazy. So the head of Americans for Prosperity, a very conservative group here in Louisiana that's funded by the Koch brothers, he came out and said that Amendment 2 will protect American freedom and liberty. It says Louisiana's current law makes it easier to send innocent people to prison. And a system that places a higher value on conviction rates than the pursuit of truth is a system that has no place in our society. And that's John Kay, who's the Louisiana State Director for the Americans for Prosperity, and you won't find a more socially conservative group than that. One thing I'd like to add, I think John alluded to this, and I wasn't there, so this is secondhand. I don't want to embellish it too much, but I read about it. A friend of mine who's a DA in South Louisiana, used to be the president of the DA's Association, is testifying before the Criminal Justice Committee in the legislature. And he used to be the president of the association, but he was appearing in his individual capacity. And one of the astute legislators said, well, sir, where is your organization on this? Where's the DA's organization? And when I was chair of the Public Defender Board for 6 years, everything we wanted to do, we fought the DA's Association. Very powerful in the legislature, and they can kill things and pass things pretty much at will. And anyway, his response was, well, the DA's association requires unanimity, and we couldn't get unanimity, so the association's not opposing this. And I think his answer, if anybody was on the fence, and Ed was there, I wasn't, but if anybody was on the fence before he testified, that pushed him off the fence and on our side in this. So
Everybody laughed.
You know, things happen for a reason, and why John decided to oppose the thing, God only knows, but I think his words helped us more than helped his side. So,
We had a unanimous vote.
yeah, so.
Thank you. All right, yeah. All right, Kelly, it's Amendment 2, elections November 6th. You got a room full of people that live in the Lafayette area, I presume. What can they do?
Get involved. Yeah, so we have a field office in Lafayette. We actually have 4 across the state in Baton Rouge, New Orleans, Shreveport, and Lafayette. And our office is located at 444 Jefferson, and we can use all the help we can get just to inform voters of what this amendment is. Because knowledge is power. And I can tell you, I've spoken with a lot of voters over the past couple of weeks, and 96% of them say they had no idea this even existed. And the majority of them don't even understand what the amendment is, much less know that it's even on the ballot. So we need help in informing the communities here in the Lafayette area that this amendment is on the ballot and what it actually means. We have a table outside where if you are wanting to get involved with the campaign and the coalition, we'd love to have you. We have a computer set up. It'll take 2 minutes to get your information, and we'll contact you and get you in the office. We have a good time. I mean, we're just out there informing communities about this thing, and this is the part that I love, because when you see that light bulb go off, it makes your day so much better. And as the gentleman here emphasized, you know, this is history. This is our opportunity to change history, and many of us I know I've always wanted to be a part of something that is monumental. This is monumental. So I would encourage every one of you to not just tell somebody else about it, but bring them to the polls. Tell them about it, and also bring them to the polls, because our voters here typically don't vote. We don't show up to the polls. So bring a boatload of people to the polls with you and inform them of this. But most importantly, get involved, and you can come see myself or Katie out there to ask us how to do that.
Thank you. Thank you very much. The text on your ballot, Amendment 2, do you support an amendment to require a unanimous jury verdict in all non-capital felony cases for offenses that are committed on or after January 1st, 2019? Anyone on the panel volunteer how you're going to vote?
Yes on 2.
All right, all right.
Yes, on 2.
I'll let Pearson,
Yes, on 2.
I'll let Mr. Cross indicate when it's time to wrap up, but I guess we could have a couple of questions from the audience if there are.
Yes.
All right. Sally.
I have a question, but I think for Norris or anyone can answer it. We talk about people who have been formally incarcerated and whether they're going to have the right to vote, and I believe they can after 5 years now. But what about the whole issue with bail? How many people who are presently incarcerated without being convicted? How do we get those folks? How could they register to vote and cast their vote when they're not free to do either?
Well, we just have to get somebody. The easiest way, we initially struggled with that several years ago, having to go to the jail, getting the sheriffs to certify who those individuals were. But one of the things we made that process easier was we took somebody with us from the voter registrar's office who actually can certify them being who they are right then and there, and then they can get the mail-in ballot and can literally vote. Because if they haven't been convicted and they're just sitting there waiting trial, they haven't lost their right to vote, and they can actually participate in the process.
So is this or does a potential voter have to request that if they're incarcerated, or do people go in there and take care of this?
No, you have to go in there and take care. There's no polling place. We've been trying to get a polling place set up inside of the jail, especially because in Orleans Parish, it was a huge population at one time. But we have been working in the past, and the strangest thing about it was the sheriff in Orleans actually captured that data of everybody who was actually in the jail, who was actually eligible to vote. And the last time we done it was like 2,000 people. Wow. And that's a whole lot of people. You know, I mean, we lost some of the people because some of them got released before the election. But one of the things, too, to the extent that folks now can actually, if they're in prison, and get out and just go straight to the polling place and vote, and so that's one of the things that we've really been pushing. And the 5 years is not applicable to everybody. The 5 years is just applicable to folks who are on supervision. Because if a person has been out of prison, he's not on supervision, he can register and vote tomorrow. I mean, it's, timeline-wise, but technically he can register to vote the minute he walks out of prison. If he's on supervision now, come March of next year, and he had been out of prison for 5 years, and haven't been inside for 5 years, he can actually register to vote. And the numbers are astronomical, because when you factor in our Constitution change in 1970, literally 75, when it became effective, and the only restriction on voting then was that you had to be under order of incarceration. We're challenging that in the state Supreme Court as we speak, what the interpretation of order of incarceration mean, because 2 years later, the legislatures took it upon themselves to define order of incarceration mean people that was on probation and parole. And we are challenging that determination. And so if that happens, if you factor in from 1975 to present day, which is almost, 40-something years, correction projected that they release 15,000 people a year, times 40 will give you like 600,000 people that kind of like would be eligible to vote. And so the thing about it is educating those people about that right, because most people believe, rightly so, given the myth that once you go to prison, you lose your right to vote for life. Prior to 1974, our 1921 Constitution, you had to get a gubernatorial pardon to actually get your right back. But this new Constitution of 1974 eliminated that qualification. And so there's a lot of people in our communities that when we're knocking on doors, their line of defense is, I've been to prison, I can't vote. And so we have to correct that messaging saying, no, that's not true. If you're not currently on supervision, you have the right to vote. And if you're on supervision, have been out of prison more than 5 years, come March the 1st, you will be eligible to vote. So there's a whole base of people amongst us that not just low propensity, but who have just kind of like opt out of the process, not understanding the value added that they bring to this democracy. We need to encourage that more so than not.
All right. Next. Yes, sir. Busher.
Right.
Yeah.
Yeah. Two questions. One is, the people who are opposed to this, can you guys talk to what are their rationales for opposing this? I mean, you presented great arguments. I just want to know what their point of view is briefly. And the second question is, does this affect, I'm not a lawyer, does this affect the appellate process at all if somebody's convicted with a 10-2 verdict? Does that affect their ability to appeal in the future?
Two answers. Number one, the amendment is prospective only. It only affects a person charged with a crime that was committed January 1 of 2019 and forward. And that was a part of the bill that was introduced in the legislature, and that was an issue. There were a lot of legislators that were concerned about retroactivity. I feel pretty confident in saying the bill would not have passed if retroactivity had been part of it. So that was part of the legislative reality that we faced, and clearly a portion of the legislation says distinctly that it only is effective January 1, 2019 and forward. Well, and the answer to the other question, the argument against it, the main argument against it is simply one of efficiency. It's what I call the efficiency argument, that it's going to make it more difficult to obtain a conviction if we have to get all 12 jurors instead of 10. Well, my response to that is that, it doesn't seem to be a problem in 48 other states, and it doesn't seem to be a problem in Texas and Mississippi, because they filled up the jails and prisons there for years, and they've always had unanimous jury verdicts. So I think the efficiency argument is a red herring. I was a DA for 6 years. I still have a lot of friends who are DAs and work in a DA's office. Look, they're competent attorneys, and they know what to do and how to do it. And I think they're just as good as prosecutors in Texas or Mississippi. And if they have a worthy case with sufficient evidence, I think they'll be able to obtain convictions without any problem. I think it's the marginal case where the evidence is weak or non-existent. Those cases shouldn't be brought to trial anyway. And I think what you will see happening, and I'd like to hear what Frank has to say about this, but I think what you will see happening is that the DAs in Louisiana will stop bringing marginal cases to trial, that they'll weed those cases out, and the cases that are brought to trial are cases that have significant and sufficient evidence to prove that the person committed the crime beyond a reasonable doubt. And that's the way it should be. That's the way the system works. What do you think about that, Frank?
I agree, and the argument I've heard is efficiency. It's more efficient. That's what the Attorney General's office came out with. It's more efficient to have this system. I've talked to a couple of judges or retired judges, and they said, well, I think you can have a holdout. Well, that's what charges are for, and if you're doing your job, you're supposed to weed out the people that you think will be holdouts. So I think the concept of unanimous jury in the United States and the way we were founded and the fact that 48 other states do it, I agree with Ed. It overrides any concerns about a holdout or, and there's articles you can check out, but there's an article I read today that says that some DAs will overcharge. Instead of charging somebody with a crime that only requires a 6-person unanimous jury, they'll charge them with a more serious crime, that a 10-2, just so they don't have to get a unanimous if they have a weaker case. So, I think it's a tool that the prosecution has. They use to their advantage, and I just don't think it's fair and based on the way our country was founded to give them that extra tool. So.
Yeah,
like I've always said, is when you go to trial under our system, the DA starts out with 2 votes in his pocket. Okay, he's already got 2 votes, and that's not right. And so, what?
No, he means the fact that you don't have 2.
Right.
You have 2 people that
Well,
vote doesn't count.
Well, the way it just doesn't matter. I mean, he knows that he's only got to get 10 votes. I mean, that's just a manifestly unfair system. But the other follow-up I would simply say is this: the criminal justice system is not about efficiency. The criminal justice system is about fairness and doing the right thing and making sure that people's rights are protected and making sure that accurate verdicts are handed down. And you accomplish that by a unanimous verdict. And in Norris's case right here, the 2 jurors in his case got it right. The 10 got it wrong, okay? And so I'm just telling you right now, you know, efficiency is a red herring. I think that that if you just look at the other 48 states, no one else is having this conversation except Louisiana.
Well, and if it's you or your relative, do you want efficiency or do you want justice? You know,
That's right.
if you're charged with a crime and you're going to go to trial, are you looking for an efficient system or are you looking for justice? And I hope everyone here is looking for justice. So.
Yes, sir.
I'm a business owner, property owner here in town, and it's been brought to my attention that the prison system at Angola is quite self-sufficient as far as finances go. I'd like to ask Kelly or Norris how this is perpetuated slavery in Louisiana.
Really through the legislature, really. The legislature requires now that a person, when I went to prison in the early 70s, you had to work 6 months in the prison for free before they paid you. Now you go into prison, you have to work 3 years before you get paid. And I'm saying pay, and don't get this vision that cha-ching. When I'm saying pay, I'm talking about 4 cents an hour. And so even in this day and age, when you go in, it's like you don't get paid for 3 years. You don't even get to earn incentive pay. And then when you earn incentive pay, in the mid 80s, it created this double good time policy that you can forfeit your earnings for extra good time. And so it just kind of like this thing perpetuated. Then here, Louisiana is one of the most harshest systems in the country in the sense of the amount of time that we mete out to people. Angola has like 6,100 people there right now. Virtually 4,500 are serving natural life sentences. And the balance of that population is serving practical life sentences. And so that's a population, when you hear people say that 85% of people is going to die there, that's true. And so it's like you said again with Colonel James. When he started this system takes care of itself. And I tell people all the time, nowhere in that prison where you go, and I was looking, you know, I have this little tick about me. I'm always counting ceiling tiles or counting light bulbs that out, and I see you got 2 light bulbs out. Nowhere in that prison where you go and you will see a light bulb out, because some inmate is going to fix it. You don't have to call Roto-Rooter. Some inmate is going to fix it. I don't care if it's 2 in the morning or whatever, some inmate is going to fix it. And so they have a built-in labor force that governs everything. The folks who are there are just there as security. That's all they do is watch people. They don't cook none of the food. They don't build anything. They instruct folks how to, but most folks come in to the prison. I went to the prison. I'm a machinist by trade. And went into the prison, and soon they look at my record and say, oh, call somebody from the machine shop to come question me about what I had in my folder about machinery, and after I answered the question, the guy said, send it to me. I was assigned to the tag plant to make license plates until I got a job in the law library. And so, you know, they understand the skill set that people have, and they utilize those skill sets to their advantage. You know, and so the challenge is, and I was on a panel in Colorado at Denver Law School on Saturday, and the question was about prison labor and organized labor, the nexus between the two. And it's because organized labor don't care about what's going on inside. It's how labor inside is being exploited. You know, because everything that goes on in the prisons, actually prisoners actually do. They maintain the fleet of vehicles that's there. They maintain all the heavy equipment, all the farming, everything that's done inside the end of the prisons in Louisiana. Inmates are responsible for doing it. And once they acquire skill set, one of the most frightening things to me happened when I was getting ready to get released. I was talking to my supervisor over the law library, and I was explaining to her that when I go back to court tomorrow, I might not come back. And she said, well, that can't happen. And it scared me to death in the sense that I thought she may have had some power to kind of like keep me there, because I had became an asset. And once you become an institutional need, you can't get transferred to nowhere else. And we've kind of like heard these stories about what goes on in the local jails, about if you're at a local jail, you're not going nowhere, because at that point you become an asset. But that value added, because, you know, my role in the law library for over 20 years, being a librarian, managing this whole library system throughout Angola, I became an asset. And so one thing I never had to really worry about was being transferred somewhere, because I understood the value added that I had there. But sometimes it worked to your detriment that you can be an institutional need, and sometimes it becomes an impediment to you moving, you know, out of that environment that you're actually in, you know? Yeah. But one thing that I encourage folks too, because a lot of folks come home and people are reluctant to hire people, and I tell everybody in prison works. Everybody has a job. It may be the electrician, maybe the cement finisher, the carpenter, but everybody has a job. And I think one of the real challenges with folks acclimating themselves back into the community is finding placement. And for years, our legislature had impediments that would prohibit guys inside from getting certain licensure, you know? I was a hospice volunteer inside. I created the hospice program in Angola that became, bar none, the best hospice program in America. I couldn't get a job doing that, primarily only because I had been to prison. And even when we created the program inside, people inside thought, oh, y'all don't need to be doing that. Y'all can be stealing the patient's medicine. It was like, really? You know, and so, you know, all these stigmas and barriers that have to be removed, but it starts in the legislature, who puts these crazy policies in place that the person who's cutting hair in the prison can't come outside and get a barbering license. What sense does that make? You know, and so this is important. This is kind of like that first step again in changing the mindset of folks in the legislature. Because like John said, that I guarantee you on November 6th at 10 o'clock, everybody that's in office and potentially seeking office is going to be looking at those returns about how many people showed up and what they showed up for. There's very limited things on the ballot, nothing to kind of like jump up and shout about. But this ballot initiative to us is probably the most important thing on the ballot probably in the last 20 years, aside the, I guess, the Stelly plane. But this probably is the next most important thing that's on the ballot for people in Louisiana moving forward.
Norris, I would like to say that I think it's the most important amendment we've ever voted on.
Yeah.
We've never voted on anything like this. We've never voted on something that reaches back 138 years into our past. We've never done this. The citizens have never voted on anything like this, ever. It's historic, like Kelly said. This is historic. It's a historic moment. And, you know, Pearson, you need to have another forum, and we can talk about the history of the Louisiana penal system, okay, because that is a completely different story. It factors into this because, let me tell you why. How we prosecute people is determined by this system. The non-unanimous jury verdict law hangs over the criminal justice system in Louisiana like a cloud. It affects how cases are prosecuted and how cases are defended. It affects everything we do. I mean, it's monumental. This is just the most incredible thing. I mean, you have no idea how important this is and how this will change Louisiana. This is about changing Louisiana, and Norris is right. We don't know what lies ahead. We don't know what's coming next year or year after next. But all I know is we've got today, and we have got to take today. We've got to do today what we can do. We don't have tomorrow. Tomorrow's not guaranteed to any of us, but we have today. And if we'll take today and do what we're supposed to do, we can change Louisiana.
All right, well, we're gonna wrap it up, and I just want to highlight a couple thoughts. Like, one, we need another forum because this isn't the only thing that we have to do, but it is in and of itself extremely historic. So, as Norris said, 10 o'clock on November 6th, we're all gonna be looking at a TV. What's that TV gonna say? Y'all have a choice in that. What's that TV gonna say? Please give a hand for our panel, all right?